Wonderful. Well, thank you so much for this invitation. We do have a lot to talk about today. There's a lot I want to share with you. So I wish I could be there in person to see you, but this is the next best thing. So my neighbors to the northwest, I'm glad to be online with you today. So today what we're going to talk about is what considerations you should think about from a legal perspective before you would sign any sort of agreement for wind energy company or a solar company to come onto your property and pay you to install either solar panels, a solar farm, or wind turbines. Now, a lot of you are probably more familiar with the wind energy because that's been going on in South Dakota much longer than the solar, and the solar is a growing area. So I'll focus just a little bit more on the solar, but for the most part, the solar and wind are very similar. I'll try to point out where they're similar and where there are differences. Now, I'm putting up this contact information because I love to hear from folks out there who are at my presentations, and I love to hear what are issues facing you. So if after the presentation you have a nagging question that you would like to ask, or just a conversation that you want to have, reach out to me right there, ktidgren@iastate.edu, and I would be happy to write back and see if we can talk after this. So my plan today is just to give you a little bit of an introduction in what's happening with solar and wind across the country, what's happening with solar and wind in South Dakota, and then I want to kind of give you a little bit of background in terms of the tax credits that really are driving a lot of this development. And then we're going to dig into the meat of the presentation, which is really the legal contract, because that's my expertise. I'm a lawyer. I'm not a scientist or anybody that can tell you about how electricity is generated or anything like that. But the tax credits as part of my tax work that I do, and then the legal provisions within the contracts that you would sign are very important for you to understand. So I'll preface it all by saying every contract is going to be a little bit different, and different companies are going to offer you different contracts. I've read a lot of contracts, so my presentations are sort of based on some general provisions that I've seen in contracts, but that doesn't mean whatever I say today would be in a contract that would be given to you as a proposal. So the whole goal of today is to kind of get you started in terms of the things to watch out for. And then really my bottom line is encourage you to seek legal counsel if you're in that position where you're approached by a developer. Don't just do it on your own. It will be well worth the investment to hire counsel just to help you walk through that. So that's where we're headed today. As you all realize, the United States is really growing in all forms of renewable energy. And so, according to the recent data, over half of all solar installations have come online since the beginning of 2020, and over 25% have come online since the Inflation Reduction Act became law, and that was in 2022. So in a few minutes, I'll talk just briefly about what those tax credits are and how those credits are driving this development. Solar comprised 54% of new US electric generation this year. So solar is really hot right now. There's a map that I pulled down from the Solar Energy Association that shows little bubbles to kind of show you where most of the activity is happening. But if you look up in your state, you've got a couple of big bubbles that you're probably familiar with what's going on there. And we'll take a look at that in just a minute. But historically, South Dakota has been toward the bottom in terms of solar energy. This is sort of new. There've only been 2 megawatts of solar installed when this was put together a couple of years ago. Number 47 in the country, and your sister state to the north was at the very bottom. So we haven't seen a lot of solar. And I'm in Iowa. I don't show up on this bottom 10 list, but I sure don't show up on the top 10 list either. So we've been much more involved in wind than we have been in solar, which is why we sort of need to get up to speed and get educated as solar continues to grow. So here was the last statistics, most recent ones that I found from the Solar Energy Association, where South Dakota was actually 42nd, moving on up, 38th in 2023. State homes powered by solar, percentage of state's electricity from solar still at just 0.47%. Solar companies in the state, you can kind of see all of that. But growth projection is to go up. And so here was your headline from one of your newspapers: solar up 3,600% in 2023, doubling again in 2024. And so what I'm going to talk about is utility scale solar. This is the solar that involves the South Dakota Public Utility Commission. We're not talking about some farmers putting solar panels on their hog barns or on their poultry facilities or powering their dairy. That's something else. There are tax credits available for that too. But what we're talking about today are big solar projects that are generating many megawatts of electricity, for which permits need to be acquired from the South Dakota Public Utility Commission, and the power from the solar projects are being sold on the wholesale market. So that's what we're looking at today. And of course, land is what is needed for these projects, and you all are landowners, and so you are the ones who are contacted if your land happens to fall in the way of these. So you're probably familiar with some of the projects that have come online recently. The 80 megawatt Falls River facility, it came online in September of 2023. And then the Wild Springs Solar Project launched March of 2024, and that one's a big one as well. So you've had a couple of really large ones come online recently. There's been another project that was granted approval, but it seems to have stalled out. Some of you might know more about this than I do, up in the Pine Ridge Reservation area. So that's really the extent so far of the utility scale solar, but it's a lot bigger than where you were a couple years ago. So you see there's actually bars on the graph now, and we do kind of expect that to continue to grow. And then, as it has been, wind is really everywhere. Wind has been the go-to in South Dakota. You all are like Iowa, where more than half of your electricity is generated from wind. So renewable energy is not going away anytime soon, and that has largely been driven by those Inflation Reduction Act credits. So not going to make you experts in credits. I'm not going to go into the nitty-gritty of them all, but I want to tell you about the two major credits that are sort of driving this. The first one is the production credit, and the production credit is the one that says if you are producing electricity from renewable sources like wind, geothermal, solar, then your facility is going to get a tax credit every year over a 10-year period. These are very generous credits. I have examples and things I could give you, but we only have a short period of time, and I want to get into the meat of the contract. So this is just a little bit of background to say this is fueling a lot of the development because these are very lucrative credits. They apply to solar and wind. Also, the investment tax credit is a little bit different. This one, you're not paid based upon the amount of electricity you're producing. This one is you are given a one-time credit when you actually install the facility. So most of the solar projects, wind projects that we're working with, those companies are tapping into the production tax credit. But there is this other credit that is very helpful, the investment tax credit in particular for producers. If you want to put solar or wind on your property to power your farm, you have tax credits available to you as well. So that's sort of the driver behind all of this. What I want to dive into are the general considerations about these contracts. And I'm probably not going to tell you a lot that you do not know already, because a lot of this is a little bit of common sense, but it's sometimes helpful to sort of think about it all as you look realistically at the document that's presented to you, if indeed you're presented with something that you might want to sign. And so remember, if a wind energy company approaches you or a solar company approaches you, they're going to have contract that is adapted by their attorneys for the benefit of the company. And so I'm certainly not casting these folks in a bad light or saying they're evil, but if I'm working for a company, I'm going to write a contract that has my company's interest at heart. right? So that means you as the landowner, you need to have counsel on your side that is going to have your best interest at heart. So these provisions are usually written broadly. They're written in the interest of the company, and there is some room for negotiation. So it's worth the investment to hire a counsel who works with these contracts to help you negotiate, particularly you got to remember, these are long-term contracts. This isn't signing up for a 2-year deal. This is something that's going to most likely outlive you. It's something that your family members are going to be saddled with. So you need to make sure that you're okay with the provisions that you're signing. And you need to understand these provisions before you sign. So all of the agreements are going to vary a little bit, but a typical structure, particularly with solar, is going to be you're starting with an option contract. And sometimes it's just a letter of intent that if you sign it, that is creating a binding contract. So don't get misled by the phrase letter of intent and think, oh, it's just a letter, the follow-up contract will come soon. Or don't get misled if it just says option. A lot of times, if you sign an option, you're signing away everything. The company itself doesn't bind itself to the long-term agreement, but you do. You're basically saying, I'm allowing you to do this, and I don't have a way out, but you do. So just keep that in mind, that the wiggle room is usually on the company's side, not on the landowner side. And what we're usually granting is an exclusive easement or lease or both. They use the words interchangeably, and they're not usually necessarily the legally defined words. What we need to understand is we are giving the company the right to control our land to a large extent, to capture solar power, to capture wind energy. We'll talk about a little bit of the differences between what that looks like between those two. But you really, in the contract that you sign, need to look for the purposes language. What is the purpose of the contract? That is going to tell you what the future rights are. So with the option, it might be a 5-year option, and the landowner is going to give the company an exclusive option within that contract, that option contract, to say, oh, if within 5 years they decide they want to acquire a full bore 40 years lease over my property, 40-year easement, whatever it is, then they have the right to do that. And they're the only ones that can do that. So I've said yes to all of it, like I said, but the company can terminate at any time. If they terminate during the option period, then my only payment is whatever the option agreement payment was. I'm not going to get paid for the 25 years or whatever the additional years are that the actual contract would be enforced. So we got to watch out for that. We also have to watch out for renewal provisions, because the option itself might have a renewal. We might be 5-year option with a 3-year renewal. We might be drug along for 8 years where we really don't know what the future of our land will hold, because we've agreed that if the company wants to put solar and wind on there, they can, but I have no way out. And they might not, right? So that gives some uncertainty for the future. So I want to talk about the definition of the word lease and easement. Legally, they kind of mean different things, because a lease just grants the possession and use of land to a company in exchange for a rental payment, whereas an easement gives the right to use or control somebody else's land for a specific limited purpose. As I said, the terms are in these types of agreements often used interchangeably, even though technically they are different. Now, the final contracts typically purport to be purchasing both, and South Dakota calls rights granted easements. And so the law actually requires a memorandum to be filed with the county land record. So this will all be filed just like a land contract would be. So just keep that in mind. Also, South Dakota has very specific law that any deed, will, or other instrument that creates a wind or solar easement has to include certain things. So have to give the description of the real property that's subject to the easement, a description of the real property benefiting from the easement. We're going to get into this a little bit later, that it's not just the landowners that actually have the turbine or the solar panels on their land that might be signing some of these easement contracts. The neighboring landowner might be signing an easement contract where they agree that they're not going to obstruct in any way the granting of the ability for the sunshine to go onto the solar panels. So these easements go not just with the land itself, but also with restricting the right to have the wind, restricting the right to have the sun. So we'll talk about that in a little bit as well. Now, there is here a provision for your protection that no wind or solar easement or wind or solar lease can be executed by the parties until at least 10 business days after the first proposed easement or lease has been delivered to the property owner. So keep that in mind. Do not rush yourself. You have plenty of time to get legal counsel. You have plenty of time to think about this. This is a really big decision. And the law recognizes that and says, you know what, we're not even going to let you execute this for 10 days. So a little bit of parental guidance there, I guess, from the state, which we have different ideas about. But in this case, it's kind of protective, because we can otherwise sometimes get a little bit of pressure. And this kind of just eases that pressure switch just a little bit. So what do these easements or lease agreements generally provide? Well, this is kind of what I also want to alert you to, is to the fact that these have a lot of provisions generally in them. You're giving the right for the company to put a lot of things on your property if they so choose. So we're first going to have a construction period. We're going to have right to access the property. They're going to be the right to build and maintain the panels or the turbines. I'm going to talk mostly about solar, but in most cases you could interchange turbine and it would be the same law. The rights in building to maintain a substation, that is often allowed in the contract. Not that everybody's going to have one of those on their property, but you got to read the contract, because in many cases you're giving the company the right to put one on your property if they so choose. The right to put telecommunications equipment, weather instrumentation, all this. So we're going to take a look at the kitchen sink, I call it, of the rights that are typically granted in these contracts. So that my biggest thing today is, as I said, that we go into these things with our eyes wide open to understand what it is we're giving up. So first of all, let's look at the construction rights. So any of these projects, of course, are going to require construction. And so during this period of time, we're usually given the company more access to our property than we would during the actual long-term lease period, because it's going to require more of our land, because they're going to be having to access it in places they wouldn't have to access it once the project is up and running. And so we need to understand for what period of time certain parts of our land will be inaccessible to us. We need to understand if our crops are going to be damaged. We need to make sure that we're getting compensated for all that. We'll talk about compensation in a little bit, but the operator may exercise its right to use all or part when the operator deems it necessary to do so. This is typical language in a contract. Who's the operator? We're not talking about farm operators here, folks. We're talking about the operator of the company. So this is the wind energy company, the solar company. They are giving themselves the right to use lots of your property typically to get done what they need to get done. They're going to come in with heavy machinery, big rigs. They're going to compact your soil sometimes. All these things, we need to take these into account when we're looking at the damages that we get. Also, we have to provide unobstructed access to and from the improvements. So you might have property that you think, well, here's where the solar farm is going to be. But the contract's going to say, well, we also have the right for any time we need to access that, we need to travel across this part of your property. And so in many cases, there's going to be roads built to actually get there. They'll construct and they'll maintain and use any roadway improvements they need to be able to get to the facilities. Also, usually it says the owner shall not permit others to obstruct or damage the roadways. So you can't interfere with these rights. If your equipment is getting in the way of the company, that would breach the contract in most cases. And then roadway improvements can include even paving or surfacing roadways with asphalt, gravel, roadway materials, all of this. So again, read the contract, see what it is that the company has the right to do. We may be familiar with, well, my neighbor had this happen and all they did was do a little dirt road and they haven't had any problems with it. And that might well be the case. But read the contract and see what they have the right to do and make sure that you're comfortable if they take advantage of all the rights that they're granted. Also, the right to build and maintain solar panels. So this usually also includes all pertinent collection facilities, roads, parking areas, whatever they need, not just necessarily what you see in a typical solar farm. And South Dakota law does allow those extra facilities as well. The holder of any wind or solar easement, wind or solar lease, or easement for essential services shall accommodate the reasonable development of another holder of any wind or solar easement, wind or solar lease, or essential services, except for competing developers. So, we were required basically to accommodate each other in these things. Also, the right to build and maintain collection facilities, right? We're collecting electricity. We're not just out here with a few panels that are bringing in the sun. That electricity that's going to be generated has to get somewhere. So usually the contract says that the company can construct, operate, maintain, replace, relocate, or remove collection facilities. And then improvements might include transformers, overhead electrical lines, telecommunication lines, all the things that go along with electric power. We need to understand what rights are we giving to the company and how would those rights that we're giving away impact our use of our property. Substations, again, we don't see tons of these, but the company may, in many contracts, construct, operate, maintain, replace, relocate, or remove one or more substations on the property. So this is usually just right there, boilerplate language, granting the company the right to do that if they need to. Same with telecommunications facilities, the ability to come in and communicate with their technology sometimes requires telecommunications facilities to be placed, weather instruments as well. Solar is very dependent on weather. They need to track that offline. There's tremendous technology that goes along with this. So just be aware of all the extras that come along with a typical project. And then also, we have the don't block the sun easements and the do not block the wind easements. And then sometimes we have neighbors that sign contracts. You might be approached by the company to say, hey, we don't want to put a turbine on your property, but we're going to put it on your neighbor's property. And here, we'll pay you this little sum of money if you promise you won't sue us because you don't like the flicker or you don't like the wind being the turbine being right next to your property. So here, we're giving you this hot deal to give you this payment so that you won't sue us for the annoying effects of that turbine. So non-obstruction easements basically say that the owner cannot engage in any activity that might interfere with the sunlight direction, cause a decrease in the output or efficiency of any solar panel or weather instrument, or otherwise interfere. So what does this mean? Well, it means sometimes trees or structures have to be removed. So if that's going to be the case, trees are expensive. Trees are worth money. Make sure that you're compensated. And so I've included here what South Dakota law says about this. The deed granting the rights has to provide the very detailed description of who's benefiting, who's being burdened, and then the wind easement is defined here. And so I'm putting these in slides that Doris can provide to you. If she's not able to do that, though, again, you just email me at ktidgren@iastate.edu. And if you forget that, you can just type in law and tax at Iowa State, and my information will pop up. You can email me and I can send you my slides. But again, these are all the terms that are defined in South Dakota law for both wind and solar. What's an effects easement? Well, this is where the owner grants the company an easement for visual, view, light, flicker, noise, shatter, vibration, electromagnetic, electrical, radio frequency interference, all these things I was telling you about. That's sort of a name that we can give that easement I was telling you about. If the developer knocks on your door and says, hey, we'd like you to sign this so that you will not sue us. And if you sign one of those, then you can't seek damages for nuisance or anything. In many cases, though, you will be compensated for that. So this is a lot. This is a lot in the typical contract. Again, this is why I do not recommend that we go this alone. I do not recommend that we go just kind of skim through the contract, sign it, and say, okay, I'm happy to get this monthly payment, or I'm happy to get this yearly payment. This sounds really great. You've really got to understand what it is that you're signing. And then the other thing that you really have to understand is what uses are going to be left for me when this is all over. So with solar, there is likely going to be no viable use remaining for your land for the area where the solar panels are. And income from these agreements has to be sufficient to replace any income opportunities that you have for that land. And this is very different than wind. This is where wind and solar are very different, because with wind energy contracts, I can have a turbine, I can plant around that turbine, I can have my cattle graze around that turbine, and it's not rocking my world too much once it's up and running. I mean, it's very disruptive during the construction term, but once that is going, the wind turbine, yeah, once I get used to the sound and the flicker and all that, my life goes on. But with solar, it is taking over my property. So instead of being supplemental income, it's really replacement income. So we have to keep that in mind as well. Now, I wanted to tell you a little bit about the fact that we are in the university setting. I know here at Iowa State, there's a project going on that I'm a little bit tangentially involved with just some of the legal aspects of it, but they're trying to figure out how to do agrivoltaics, where down the road, maybe what we could do is get to the point where we could plant some crops that go along with the solar panels. But folks, we're kind of not quite there yet. But maybe down the road we'll be there. And so one thing to think about if you're signing a contract is to have the language such that if this emerges down the road where this is actually viable, that you would have the opportunity to actually do that. Because this is kind of going on a little bit throughout the country, mostly in test sites, but it is kind of working. And then the other thing, this isn't generally compatible with CRP contracts, with EQIP, with any of that. So that is the big thing I've got to tell you, is that you really need to make sure that you understand that when you're getting this income, it is the income that you're getting for the land if you're talking about solar. And these contracts are long. And as I said, they usually are in stages. So we usually start with that option contract. And again, it's often 5 years, but sometimes it's less than that. And so during that time, that's when we have all the uncertainty that we've given up everything, because if they want to go on and go on for a 25-year term or more, 50-year term, they can, but they might only be there for 2 years, and I might only get that small payment for all that uncertainty that is generated. Then there's going to be that construction period, which can take some time. And as I mentioned, the construction period is quite disruptive. During that time, you'll probably be closed out of certain portions of your field that you might actually be able to cultivate after the project's up and running. So it will be a larger area of your land that's impacted. So again, we need to make sure that we're negotiating proper compensation during that time. Then there's usually a 25-year term at least, and then an option to extend it for another term. So again, when we have an option, who's the option with? It's in the hands of the company. So here's what typically happens. The company doesn't want to lock themselves necessarily into anything longer than 25 years. So they might give you a 25-year initial term where then you are guaranteed that you'll get income for that 25-year term. But then built into the contract is at the sole discretion of the company, we'll extend it for another 25-year term. So what have you done? Well, you have now bound up that land for 50 years. So I said for most of us, this is way beyond our life expectancy, so it's going to go on to the next generation, or if you sell the property, to whoever purchases it from you. So you're really burdening that land with something that will impact any future owners. The easement is void, though. This is very helpful language. In South Dakota, you have protection by the law that if energy is not produced within 5 years of the effective date of the agreement, the easement is void. That is very helpful. That is not in place in a lot of states. So terms are very long. That's my big word of warning. Make sure that you're thinking clearly about that. And when you're negotiating payment, make sure you're thinking about all of this. So the payments for the option term, they're usually going to be a lower yearly payment. So it's just kind of like, even though you've said, okay, I'm committing that they can do this and I don't really have any way to stop them, I'm still going to get not a real big payment for that. And then during the term of the actual lease, usually it's a yearly payment for the solar. Solar is almost always yearly payment based on the number of acres that are actually used. And there is room for negotiation in this, so make sure you're doing that. Also, the agreement might try to delay the determination of the actual acreage until after it's signed. It might have some language that says, well, whatever acreage we end up actually needing, then we will pay you this amount per acre. But I like to say, well, I think you might need a little more certainty than that. So I would advocate for knowing exactly what acres they're going to use. Also, it might provide for an inflation adjustment after so many years or on a second term. If it doesn't, you need to insist that something be in there because, $1,000 a month right now might sound pretty good. $1,000 a month 25 years from now might not be so good. So make sure that you're thinking long term on that yearly payment or that monthly payment. Also, with all the uncertainty that is existing, make sure that you are negotiating a fair price. Really work with somebody that is somebody who understands these contracts. This is a place where you seek out an attorney who is used to negotiating these on behalf of landowners, not necessarily. If you have somebody that used to negotiate on behalf of wind energy companies and is now working with landowners, those folks are really great too because they really understand. So and just look for somebody that has expertise in this. And then make sure that we're compensated for all the restrictions that are going to be impacting us during construction. Any sort of crop damage, we've got to have it in the contract how we're going to get compensated for our crop damage, for any damage they do to fences, for damage they do to irrigation, any of our facilities, any of the soil compaction, anything like that. That has to be in the contract that we need compensation for that. Now, we could consider liquidated damages clause to avoid disputes later. This is something to kind of work with your attorney and figure out what you want. But again, if you do not think of the compensation in advance, it's not going to be an option for you after the fact. You're not going to be able to go to that company and say, oh, hey, you damaged more of my fields than I thought you would. They're going to be, well, what does the contract say? I mean, the contract is going to be king. So again, as I said, we have to remember once we sign, we are not going to be able to get out of this contract as a landowner. The only way we're going to get out is if they do not develop the energy like they promised, or if they do not pay you. So if somehow you're not getting paid, there will be a way down the road for you to get out of the contract. But otherwise, if there's a breach, if they don't do things quite right, you'll have an action for damages, no jury trials, but you will not be able to just terminate and get them off of your property. But on the other side, if you read the contract, most of the time the company has the right to terminate at will. Here's typical language. At any time during the term of the agreement, as to all or any part of the operator property, termination shall be effective 30 days after written notice. This is why in a lot of cases you need to figure out how the compensation will work if they would somehow terminate, what you're giving up, if it's going to be a shorter term than you thought. And then once it's terminated, what happens? So generally the company has to remove all the improvements. They have to restore the area formerly occupied by the improvements to substantially the same physical condition that existed immediately before the construction. And that's because we got some legal protections there. It's called decommissioning. And so projects that are authorized by the Utilities Commission actually require a bond for this process, because the idea is, well, if they go bankrupt, then yeah, sure, the law says they have to do all this, but they're not going to have the funds to do it. So that's why there's a bond for the larger projects. But if you're a landowner that is working with a smaller company, and you know, if it's not over 100 megawatts, it's not going to be approved or permitted by the Utilities Commission. So you're just dealing with the contract itself. You need to make sure that you negotiate this, that you get a bond in place to protect yourself so that you're not stuck with paying to get all the solar facilities off of your land in the event that this company does not make it financially and they abandon the contract. Also, at the landowner's request, all or part of the roadway improvements may be left for use by the owner. So if you like the road they made and you want to keep it, you can keep it. That's all part of the legal protections that are based in there. And then just remember, as with any of these things, the company is going to have a lot of rights. If there's a regulatory suspension or a force majeure, the term will probably be extended for the number of days impacted. So, you know, if there's any issues that impact the ability of the company to do what they're supposed to do, then maybe the option period will just be automatically extended. Also, the company has the exclusive right to use the property for its purposes in most cases. During many parts of the construction, you do not have the right to go on and plant crops or anything, so you need to make sure that you're getting compensated for that. Company does not have to build panels or complete the project. Company can contest the validity of any law, regulation, assessment applying to the land, and the owner must cooperate in any reasonable way in that. I'm just reading you a couple of typical provisions that are in the contract. You got to support the company if they're going to go and complain about their assessments and all those things. Also, the company usually has the right to mortgage its interest to somebody else. It has the right to assign its interest to somebody else. So all those things, you might be working with one company today, but 10 years from now, it might have switched hands 2 times. And that's all part of the contractual language that that's okay. They can do that. Now, what about property taxes? So you have to continue to pay the property taxes on your property. It's still your property. See, that's the thing with this. These folks aren't buying your property. They're buying an easement or they're engaging in a lease with you. So they have all these rights to your property, but you are still the owner. So the way the contracts work is you are responsible for the property taxes on the land, and the company is responsible for the personal property taxes on all of the facilities. And so if the land is changing classifications because it's no longer agricultural land, you need to also make sure that the compensation in the contract is taking care of that. Because you're getting an increase in taxes, you need to make sure that the company is picking up that difference. You also need to watch for indemnification provisions. You need to make sure there's adequate insurance. A lot of times the company does agree to defend, indemnify, and hold the owner harmless from claims resulting from its own negligence. But then the owner, you, the landowner, is required to indemnify, defend, and hold the company harmless from claims arising from your negligence. So again, watch out for liability. Talk to your attorney about what all those provisions mean. Think about if somehow you have livestock that escapes from one part of your farm and the cattle run onto the solar the field and damage those panels, what does that mean? And how does that work with your insurance? And so usually the owner is an additional insured, but is the insurance promise going to be enough for you? You need to watch out. And a lot of times, the reason why we don't see a lot of these provisions or these contracts floating around, even on the internet, there's not a lot of opportunity to pull them down. And that's because almost all of them have confidentiality in them. And you're not really free to share them with anybody except your attorney. So that's another thing to keep in mind in terms of you're not just left with a huge amount of information that you can kind of comb through. You've got to work with an attorney who has seen a lot of these, because those are the folks who are going to be able to help you know whether this is typical, whether this is fair. They're going to look for things that are going to be in your best interest. Again, we already kind of mentioned this, but if the company goes bankrupt, if the tax credits dry up and this doesn't fly and they don't make money and they go away, what are your rights, right? Make sure that you have some bonding in there to help you. They're not liable to perform the obligations imposed on the operator by this agreement if there's a foreclosure. So, a lot of times the contractual language, even in that, is going to be for the benefit of the company. So think about what this would interfere with, particularly with solar. It's going to interfere for sure with your farm lease, any CRP contract, any conservation easement, CSP, equip contracts. Make sure you investigate all of this. Make sure you work with your lender if your property is mortgaged. All this has to take place before you sign anything. And then what about taxation? Doris mentioned that tax is sort of my specialty, and typically, if you are getting a yearly rental payment from the solar company or even from a wind company, if it's like a yearly payment, it's going to be treated like a rental payment. It's going to be treated like you're cash renting your land. And so it's going to be taxed as ordinary income. The only good news is you do not pay self-employment tax on that. Now, sometimes if you're selling a long-term easement, so if you're selling them an easement of 30 years or more and you get a lump sum payment in exchange, sometimes you might get to treat that as capital gain, which of course, capital gain rates are maximum of 20%. Most of us pay 15%, and ordinary income tax rates maximum 37%. So final thoughts. My big news or my big urging is if you're in the situation, seek trusted, experienced counsel. Consider all the things you're giving up. Don't be afraid to negotiate, and talk to your heirs and successors. Make sure that they understand that land, that family land, you're thinking of burdening it with this contract. And in many cases, it might be a benefit to you because you get extra income. So I'm not suggesting that you should not do this, but I'm just a lawyer, and lawyers always like to give the warnings and the things to consider. So those are my things to consider for today. Again, I wish I could have been there in person today, but thanks for your gracious invitation, and I wish you all the best. And again, do not hesitate to reach out if you have questions or want to contact me after.